That's what I thought. Okay, it is good. All right. All right. All right, if everybody's ready, I'm going to call the case. Okay. This is going to be cause number 638188, the state of Texas versus Hannah Harrison.
Judge, I need to forward her the logon because I wasn't sure that I was sending some emails to Aleda because I wasn't sure if we're getting a new logon. So let me contact her and tell her to log on with the old
Okay.
info. Okay.
That's fine.
I was just on the call with her, so.
Okay.
Anna, you have the logon information I
It's
sent
going
you
on
for
down.
the 10 a.m. hearing, right? Go ahead and log on, okay? Okay, bye-bye. Okay, she's gonna log on right now. She was waiting to see which, I kind of assumed we got a different logon, so.
No, I think it's probably the same one because basically.
No, that's fine.
The same all day. Let me see. Well, the internet was really erratic today.
Yeah. I went and got a flu shot and a booster shot on Thursday.
Where'd you
It
go?
really it didn't affect me at all, hardly. I was kind of surprised.
I got my flu shot Friday, but I still have to figure out where to go to get my booster.
Well,
How'd
I
you-
went in to get the flu shot and they said, well, do you want to get a booster? And I said, yeah, actually, we can do it right now. And that was just at Walgreens.
At Walgreens. Oh,
Yeah.
okay. Well, that should be easy enough. I was at my doctor's office and I sort of thought maybe he would give it to me, but apparently that's not the plan. So I did get my flu shot, but my arm is still all swelled up. You didn't have any, you know what? It was because I'm allergic to latex and I left the Band-Aid on until I even took my shower with it on, forgot all about it. Okay. Anyway, okay, Miss Hannah, I see you are here. Okay, if you will, please unmute yourself, ma'am.
Okay, can you hear me?
Okay, just for the record, you are present. She is not going to be needing to testify. Is that right, Mr. Grancy?
Well, I may need her. You know, a lot of these records that we're going to use will be, you know, they're public records and they're available to the court and everything, but I think she'll need to testify as to some of the harm the delay has caused.
All right, then let me go ahead and Ms. Hannah, would you please raise your right hand so I can swear you in? Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am. Yes, Your Honor.
I'm sorry, you need to
Yes, Your
increase
Honor.
your volume needs to be increased.
Okay.
Would you say that again? Because we're having a record.
Yes, Your Honor. I swear
Thank you,
to
ma'am.
God the
I
truth.
heard that now. Thank you very much. You may lower your hand. All right, this is cause number 638188, the state of Texas versus Hannah Faith Harrison. Council, please make your announcements.
My name is Kurt Granzi. I'm here for Hannah Harrison, and we're ready.
Rep Bosis for the state, and we're ready.
And this is a motion it says motion to suppress, but it's actually a motion for speedy trial. Is that correct?
That's correct, Your Honor.
All right, so at this time, since you are the movement, I don't know. Does the burden still stay with you?
Yes, I believe, Your Honor.
All right,
I'm
so-
the moving on this, and I don't think there's a shifting on it. There may be a shifting after the delay is sufficient. I didn't research that, but
all right,
I think we
yes.
can meet our burden.
All right, you may proceed then.
Okay. Judge, in this case, the facts are a little bit convoluted, but some of the facts are pretty clear cut. And this deals with the right to speedy trial under the Due Process Clause of the Fifth Amendment and the Sixth and 14th Amendments to the United States Constitution, Article 1, Section 10 of the Texas Constitution, and Article 1.05 of the Texas Code of Criminal Procedure. In this particular case, Ms. Harrison was arrested for DWI on September 14th, 2018. She was taken to a hospital, and her car was impounded. And then shortly after that, she was arrested and placed in the Hays County Jail for a drug offense. And she stayed in the Hays County Jail for a period. She did bond out, but she got rearrested. And eventually, this long, drawn-out affair, and she was held for various periods from September 18, 2018 forward. But the main period is she was held in custody. Well, let me back up. I think that this is probably important. Hannah was in the Hays County Jail from September 18th, 2018 to January 5th, 2019. So that was close to 4 months there where she was held in the Hays County Jail. Then she was transferred to TDC. And she was in TDC from October 1st, 2019, where she was sentenced to 4 years. And she was ultimately released on parole November 2nd, 2020. And keep in mind that she was arrested for this offense in September 2018. No time during the period that she was held at TDC was she informed that there was any warrant, that there was anything occurring in Bexar County. In fact, when she came up for parole the first time, they did a background check and they told her that there was nothing out there, nothing outstanding. Not until she came right up for release was she informed that there was a case in Bexar County. And she was finally released on parole November 2nd, 2020. She's in this case because of, well, I think what I'd like to do at this point is call Hannah to testify some of the particular facts on her being held, as well as when released and kind of the status of her case and the harm that's occurred to her because of this delay.
Okay. At this time, you may call her.
Hannah, please state your name.
Hannah Faith Harrison.
Okay. And Hannah, do you recall September 14th, 2018?
Pieces of it, Your Honor, and Mr. Hurt. I do remember, like I said, enough of the night. when
Okay.
they-
Okay.
Ms. Mendez, can you hear Ms. Harrison?
Yes, Judge.
Oh,
So
okay.
far, so good.
Okay. Hannah, to kind of, do you recall the dates when you were held after your arrest on September 14th? I mean, the dates when you were held in San Marcos and then also held in TDC?
Yes, sir. And I have all of those dates even written down.
Well, if you could maybe just summarize for the court the dates that you were in the Hayes County Jail and then the dates that you were in TDC.
Yes, sir. So 4 days after this incident in Bear County, 9/18 of 2018, I was incarcerated in Hayes County, which then, as Kurt mentioned, I bonded out in January 2019 and was rearrested July 25th of 2019. So from 2019, July 25th, I sat in Hayes County until 10/24/2019, and I was transferred to TDC. And that I've stayed in TDC from 10/25/19 until November 2nd, 2020.
Okay. And during that time, when you're held in TDC, when's the first time you found out about the case pending in Bear County?
I found out about the case pending in Bear County September 4th of 2020.
Okay. So you found out about the case in Bear County nearly 2 years after the incident, is that correct?
Yes, sir.
Okay. And how did you find out about the case in Bear County?
So parole, they will do a review every 6 months. So my first review, or if you're eligible for parole by the time you get to TDC, which I was. So my first review in December of 2019, they did my background check, no warrants. They reviewed me in June of 2020, no warrants. So in September, I received a letter in the mail from the parole board that said, hey, you have a warrant. You no longer are eligible for parole at this time. Or until this
Okay.
warrant is handled. So right in the
Okay.
September area of 2019. I'm 2020.
Okay. And so this warrant that occurred delayed you getting out on parole, correct?
Yes, sir.
Okay. After you found out about the warrant out of Bear County, what did you, or I guess more particularly, you got your dad involved, correct?
Yes, sir. He's always been supportive and wanted to find a defense attorney immediately.
Okay. And so then we tried to figure out, I was hired and we went about trying to figure out some way to get the warrant so you could get out, correct?
Yes, sir.
Okay.
Let
And
me interrupt you a second. How can I increase the volume for my? Okay, Miss Harrison, you just need, because I can hear you, but it's a little bit muffled, and so it's not always clear.
Is
Uh,
that any
okay.
better?
try
you-
talking closer to the mic, maybe.
Yes,
Are you-
sir. Honestly, I'm trying to find the mic on this new computer, but I'm assuming it's somewhere over here. Is that better?
Okay, yeah, that's better, but it's still a little muffled. Are you using a telephone or a laptop or what?
It's a desktop, ma'am. I'm not
Desktop.
sure, Your Honor.
Okay,
I bet you the mic is up on, if you look on the top center of the
Oh.
screen.
Yes, sir. That's kind of why I'm up here like this. I see 3 little buttons. I'm assuming one of them
Okay.
is.
Well, maybe
Do
just
that
tilt
again.
your screen. Okay.
Maybe her volume. I don't know. Would adjusting your volume help?
yeah. Can you find the settings and see you can increase the volume?
So
I think
my
she's kind of
volume-
soft spoken. Maybe you could speak up, Hannah.
Yeah, my volume is already all the way up.
100, okay. All right.
Did
So
you need
if-
any of that repeated, Your Honor?
No, I will have a record. I will be able to see every word, but it's
Okay.
just, I want to follow along. And so
Okay.
I'm not getting everything she's saying. That's my concern.
Okay.
Okay. You may proceed. Sorry for
Okay.
the interruption.
No, that's fine. If you're not here, we need to adjust it. And so when it was time for your parole, they told you your parole was going to be delayed because there was a warrant out of Bear County, correct?
Yes, sir. Is that
Okay.
if I may ask, is that any better? I was able to find one setting where I might be able to have turned it up.
Yes, that was much better. Thank you.
Yes, ma'am.
Okay. And so, and then, and I want to just take you back to, so you spent approximately 2 years incarcerated after the date of the arrest, and that almost coincides with the charge, correct?
Yes, sir.
Okay. And when you got out, and I was able to collect the evidence on the case, I asked you to contact a witness, correct?
Yes, sir.
You have any luck locating that witness?
No, sir. The witness that I needed the most to contact was, I had a phone number and a Facebook for him as contact information. So since then, I have multiple times messaged his Facebook, texted and called the number, both of which are inactive. And I even went as far as to check TDCJ, just in case, and I've not been able to find his name located there. So at this point, I've exhausted all my options on knowing
Okay.
how.
Who is this witness?
His name is Sebastian Torres.
Okay. And what would Sebastian be able to offer the court in testimony?
He would be able to testify that I was not driving. He was the one driving as we pulled in and parked at the gas station. And he actually had my keys in his pocket and he left.
Okay. And when you say he had the keys, he left the car running, correct, when he left?
Yes, sir.
And it's, when you say keys, it's actually a key fob, right? It's not a key like you put in the car.
Yes, sir. Part of it is a little key inside, but you use the fob.
Okay. And with that, so you did not have a key fob when you're sitting in the car and it was running, correct?
Yes, sir.
And you could shut the car off, is that correct?
Yes, sir, but I would not have been able to turn it back on.
Okay. And how did you eventually go and get the car out of the pound?
So after being taken to the hospital and being released on my own accord, then Sebastian could testify that he was the one that picked me up with a friend of his and took me to the impound lot.
Okay. And Sebastian had the key, correct?
Yes, sir. I was handed the key when I got into that vehicle with them, and at the impound lot, I was left with my key.
Okay. And I think that's all I need from Hannah, Your Honor.
All right, you pass the witness.
Pass witness.
May I proceed, Judge?
You may.
All right. Hi, Ms. Harrison. My name is Brett. I'm the prosecutor for the state. I just have a few questions for you. So you said your friend Sebastian was the one driving the vehicle.
Yes, sir.
But didn't the police find you in the driver's seat of the vehicle?
Yes, sir. So roughly between 8 and 9 hours after initially arriving at the gas station parking lot, I had been in and out of my vehicle. And so I ended up moving to my driver's seat. My phone charger was there and my seat settings were already preset to me. And so it was more comfortable. I'd been there for so long, sitting in one spot, I'd gotten out, walked around, climbed into that side. So that's why I was in the driver's seat with no intention to go anywhere, knowing could not leave, was not trying to.
Okay. And when the police came and investigated the scene, did they take you to the jail or did they take you to the hospital?
They took me to a hospital.
And from the hospital, were you taken to the jail or were you released at that point?
No, sir. The police officers actually ended up leaving before I was even discharged from the hospital. With the reminder that I needed to present my blood results in court. And then, so from there I was picked up and taken to the impound lot.
Okay. But your friend came and picked you up, right? It wasn't, the police didn't take you to the jail from the hospital.
No, sir. Sebastian was able to pick me up right outside the hospital doors once I was released from their care.
And so this case was not the reason that you were held in the Hayes County Jail.
No, sir.
Correct. So there was a separate case in Hayes County that, and that was the reason you were held in Hayes County Jail?
Yes, sir. I had been fighting a previous case that's kind of due to the multiple incarcerations. It was all based off of one initial incident, and that ended up leading me to TDC.
Okay. So as far as you know, this case wasn't the reason that you ended up in TDC.
No, sir, not in any way, shape, or form.
And when was the last time that you had any contact with this Sebastian person?
It had been maybe a day or two after September 14th of 2018, this incident. And then I was arrested, never to have spoken to him again.
Okay. No further questions at this time, Your Honor.
All right, thank you. Anything else for this witness, Mr. Rancy?
Just something real quick, Your Honor.
All right.
Anna, when you were taking you're not arguing when the officer actually, when you were found in the driver's seat of the car, you're not saying that you were not intoxicated through alcohol or drugs or anything. You're not saying that, are you?
No, sir.
And the officer actually detained you. You weren't free to leave when he took you to the hospital, correct?
Yes, sir. At one point, I was actually handcuffed to the bed.
You were handcuffed to the bed?
Yes.
Okay. You weren't free to leave.
No, sir.
No one would think that. Okay. When you say handcuffed to the bed, that was in the hospital.
Yes.
Okay. Nothing further.
All right. All right. So do you have any other witnesses that you would like to call? Unless the state has more questions at this time.
Let me just ask one or two more questions, if I may, Your Honor.
Sure.
Can you tell the court why you were taken to the hospital?
Yes, sir. So when police arrived on scene, woke me up, I realized, I was intoxicated, and I told the police officers I was not exactly sure as to how that led to be so relevant, or so, it's not the right word, I'm sorry, so presentable. I had been asleep for hours, and prior to that, I had been a little nervous and uncomfortable feeling at the house we were at, which is why Sebastian took me to the gas station. Initially, he was going to take me home.
Mm-hmm. So did you ask to be taken to the hospital?
Yes, sir.
Okay. So you had requested that you weren't taken to the hospital. I mean, I understand you weren't free to leave, as your attorney pointed out, but they didn't force you to go to the hospital against your will. You wanted to go to the hospital.
Yes, sir. I wanted my blood drawn actually to make sure, see if anyone had, tampered or I'd ingested anything unintentionally due to somebody else.
I see. Okay, no further questions at this time.
All right.
Nothing
Mr.
further, Your Honor.
All right. Thank you, Ms. Harrison. Do you have any other witnesses, Mr. Grancy?
No, Your Honor, and just so the court would know, I do have some of, and I don't know if they're available, they are public record and it's stuff held by the state, the jail records that would back up the time frame that she described in the time frame in the motion. We have her TDC records and that I could submit to the court, obviously, if it was in person. But I can get those to you if you'd like to see them.
Would the state have any objection to that?
No, Your Honor, I would not.
All right. Well, I'll be glad to receive those when you get them.
Okay.
All right. So I guess basically, so the prejudicial delay, I guess, the presumptive prejudicial delay was from October 2019 to November 2020. Is that what I heard?
I think it's September 2018, Your Honor.
Okay.
Until she found out about it, which was, or even really up until today. However, I think some of the delay caused by COVID might be neutral as to wouldn't be held so strongly against the state. But that entire delay when she was incarcerated, that they would have, that entire period would be held against the state. They could have got a blue warrant. They could have brought her over. They could have done a lot of things that would have mitigated or eliminated the harm. I mean, it's not just the delay, the harm that losing a witness. She was also denied getting out of prison because of the warrant that was put out, and she just found out about it at that time. If you recall, we approached the court and we tried to figure out a way to clear this up at the time, because I think everybody recognized I'll say the injustice of, waiting just shy of 2 years to file the case against her. And then you file against her and don't even give her notice of it, and she's sitting in prison. Second, the third harm is by waiting so long to file the case against her, she's not guaranteed to get credit for the time. If she's convicted of this offense, she's not guaranteed to get credit for that time. However, if a warrant had been put out for her, if they had charged her in a timely manner, she would have more than enough time to satisfy any potential sentence in this case. But because of the delay, she's pretty much wide open to a brand new case, brand new time.
All right. So I'm looking at the notes I have made while this testimony was going on. I think you said that after her arrest, she was in custody approximately 2 years. So is that what you are saying would be the presumptive prejudicial delay?
Yes.
Okay.
Well, and plus there's another, it's been over a 3-year delay at this point. However, the full 2 years of it, there was no COVID, there was no reason why something couldn't have been done with this case.
Right. So basically, the case law I have seen is pretty much the presumptive prejudicial delay is something like 8 months.
Yes.
But if in this case, you're alleging that it was roughly 2 years. Mr. Boses, what do you have to say about that?
So, Your Honor, am in agreement that, or I concede that the presumptively prejudicial delay is present in this case. I don't argue that there is no presumptively prejudicial delay. However, I would like to make a few counter arguments to some things that the defense said. So, for example, the defense asserts that the beginning of this inquiry should be September 14th, 2018, which is the alleged offense date. And it's true that police came to the scene because there was concern about possible DWI, and they investigated, and there was an intent to place Miss Harrison under arrest. She was detained. However, she was not actually arrested. She was taken to the hospital at her own request, as she said, and from the hospital she was released, and she was not taken to the jail or booked or magistrated. And this case, this DWI in Bexar County, was filed at large. And so, since this is a speedy trial inquiry on specifically the DWI, the correct starting date for the inquiry would be either the official date, the first arrest, or the filing of the information, whichever comes first. So typically in a DWI, the person's arrested at the scene and the information is filed a little bit later, and you would start with the arrest. But in this case, she was not arrested at the scene. And the case it did take a while to file, that's true. However, that can be chalked up to the large amount of cases that go through the Bexar County system. And while that does weigh against the state, yes, it does weigh against the state, but filing of a case, that has to do with the statute of limitations. That's what protects the defendant from having cases filed against them. Speedy trial has to do with after the filing or after the arrest. So this case wasn't filed until April 28th of 2020. So really, the speedy trial inquiry should begin from that date, 4/28/2020, rather than September 14th, 2018. So that cuts a lot of time off of what the defense is alleging as far as her prejudice when it comes to her speedy trial rights, because September 14th, 2018 to the filing of the case, that has to do with the statute of limitations. If she wasn't placed under arrest, she was released from the hospital. So the speedy trial inquiry should not begin until April 28th of 2020. And even then, I will concede it's now November 1st, 2021, and the case has not been resolved. So there is, even measuring from that date, there is a presumptively prejudicial delay, but I believe it is much smaller than what defense was initially arguing. And then my follow-up argument to that would be that, I guess I'll just finish with this. The point of the speedy trial right is just that, to give defendants their right to trial so that they can fight the case and present their side. The point of speedy trial is not to get a dismissal, and that's, in the governing case law, Barker v. Wingo, they say that explicitly. And I would just like to bring the court's attention to the fact that this case was set for jury trial about a month ago, I believe. It looks like, or it was set for a bench trial. I may have misspoken to jury trial. It was set for a bench trial about a month ago, and that was canceled. We did not go forward on that. Not because the state wasn't ready, but because defense requested that we not go forward with that bench trial. And so I believe that should be taken into account when considering that now they're seeking a dismissal based on what they say is a denial of her speedy trial right.
Okay,
Judge, if I could address something.
all right.
To say she wasn't arrested, Your Honor, Hannah would be the first to say she was not in a good shape when she was sitting in her car. The officers, she wasn't free to leave. They handcuffed her to the bed. They instructed the hospital to draw the blood. And to say she wasn't arrested is, you know, I guess they want to throw out the blood because that's the only way that they have the right to do that if she's under arrest. Secondly, this delay caused substantial harm to her. She sat in jail or sat in prison longer because of this case, which if she had found out earlier, she could have got a bond set, could have got that all set so she could get out. The witness who is crucial that could testify that she in fact did not drive to the location was left in the passenger seat. There are some witnesses, store owners that were there who said that the car was running out in front for more than 8 hours and she was getting in and out of the car. This is going on 3.5 years now. And she has a witness who she has a name, she has a Facebook, but we can't locate. I mean, he's probably long gone out. All his contacts are inactive. And this witness could corroborate everything she said. And this is a witness that had the key fob that took her to get her car. She didn't have the ability to start the car. If she shut it off, then she was guaranteed a tow. So she sat and waited for somebody to show up. And now she finds herself without a witness. She finds herself not necessarily guaranteed credit because the state delayed, and the state delayed right until the statute of limitations. Before they filed this, there was no reason other than harming this client. And the continued delay, you know, we had offered to do the non-jury because she wanted to get this over with. But I made it clear I need to talk to her. I haven't met her in person. And she needs to go over view the videotapes and physically see the evidence. And that's the only reason that, it's been like about a 30-day difference between the proposed non-jury and jury date. She was interested in doing the jury date because she doesn't want to wait any longer. She wants to get this behind her. And this has, like I said, because of the delay, is missing a witness, probably the only witness that's really relevant. And she's missing the opportunity to require that any sentence be concurrent with the time that she's already served. So she would have a credit for time served guaranteed. And the delay in getting out. I think she's been harmed substantially because of the acts of the state. That's it, Your Honor.
Okay.
May I reply to one point,
Yes.
Your Honor?
Yes.
I would just like to argue that there was no effort or intention on the part of the state to prejudice Ms. Harrison. From what I understand, she had a parole hearing and there's a possibility of her being allowed to be released from jail, but it was, I think she said it was maybe the second or third parole hearing that she had, third, I believe, and this warrant came up and it delayed her being released, they say. And it seemed that defense was arguing that, you know, the state intentionally waited until right before the statute of limitations was up and intentionally waited while she was in jail. And I can, you know, confidently tell the court that there was no intention to harm her, no intention to specifically wait. Like, oh, well, we could file this earlier. We're not going to until the last minute because we want to prejudice her case. I mean, it's well-known fact that Bexar County is an incredibly busy county with thousands and thousands of cases. And while that doesn't mean that we should get a completely free pass when it takes a long time to file a case, the fact is that the law has established there's a 2-year statute of limitations on misdemeanors. There's, you know, nothing in the law that says that it's wrong for the state to file 18 months into the 2-year statute of limitations. And that happens sometimes because we have an incredible backlog of cases. And it's just because of that. It's not because of intent to harm the defendant or to prejudice her. And, you know, there was no knowledge of, when the warrant was issued, there was no knowledge on the part of Bexar County prosecutors as to how this might affect her status in TDC right at that moment. So while my argument is that that can weigh against the state slightly, and I believe that's how the governing case law would dictate, but it should not weigh heavily, as defense seems to argue, as though we were purposefully trying to prejudice the defendant.
Thank you. All right. Is there anything else you would like to argue, Mr. Grancy?
Judge, just very quick, I think that the state is missing a point. And that is that there was there was a statutory, speedy trial right. There's the constitutional, but no place on when you start talking about your constitutional right to a speedy trial, one of the issues is if there is a delay in filing a case or filing an indictment, their behavior can be excused. If there's a reason for it, if they're investigating, if they're interviewing witnesses, they were doing nothing on this case. All you have to do is watch the video and realize there was nothing to do with this case. All they had to do is file it, but they didn't. And yeah, it may have been just a mistake, a screw up, slip through the cracks. But for whatever reason, what they did harmed my client. She was never sent any notice to her home. She was never, if they had just went online, they would have seen where she was and they could have informed her, but they did nothing. And, and so she's sitting in TDC being told nothing's filed, nothing's filed, nothing's filed. Well, then when she's supposed to get out, they say, oh, we can't let you out because this warrant just popped up. If it popped up a year earlier, it could have been cleared up. We could have asked for blue warrant, The case this case could have been over 2.5 years ago. And that's it, Your Honor.
All right, thank you very much. Is there anything else you want to add, Mr. Bosis, before we conclude?
Last point I'll add is simply to reiterate that I believe under the governing case law and in regards to speedy trial and the difference between that and statute of limitations, that the main issue that's being raised is that state didn't file the case sooner, which again falls under the purview of the statutory of limitations. Speedy trial has to do with from the time we filed the case until or have arrested the defendant to the defendant getting their trial. And I believe that while there was a delay in filing the case, it's not a problematic delay because if it was, statute of limitations would have taken care of it. And the case was filed April 28th, 2020. It's now November 1st, 2021. That is a normal length delay, happens all the time in misdemeanor courts in Bear County. We have many, many cases, especially during this COVID time period, that were filed around the same time and are still ongoing at this point. And so I don't believe that the case has been proven that we have violated defendant's right to speedy trial. And so I don't think the court should dismiss this case.
All right, thank you. All right, well, I'll have to be clear. Ms. Mendez, have you had any problems hearing everything that was said?
I don't believe so, Judge. I would have interrupted if I did. So I believe I did catch everything.
For some reason, my speakers are very
Like muffled.
unreliable today. There's moments where I can see people talking and I cannot hear everything that's being said. So I will need to follow the record pretty closely. I'm sure that I got the most important part, but it's what I don't know that I worry about. So, and I started to interrupt at one point again, but, and I realized that Ms. Mendez probably would have said something if she was not hearing everything. So, and they have amazing equipment that is very helpful. So I will take time to look through that, and I do have made notes. So I'm going to take this under advisement. Today is the 1st of November. I will try my best to give you all a ruling within the next 2 weeks. We are all so busy right now that I cannot promise faithfully that I will do that, but I will give it my best effort. So we do have this trial reset for the end of January. So I will get it done in time for that.
Okay, thank you.
Thank you very much. All right.
Okay,
This
bye-bye.
is adjourned. Take care. Thank you.
Thank you, Judge.
Thank you.
And Your Honor, we have Mr. Christopher Pettis that has come in.
Oh, Mr. Pettis, yes. In the courtroom or where? Oh, yeah, I see him. Okay. All right, Mr. Pettis, good afternoon. Who is your client, Mr. Pettis?
Veronica Vega, I believe.
I don't think, I do not remember seeing her name, but 670452. Okay, she has not been here today. Mr. Pettis, have you had any contact with her?
I have not.
Okay. Well, do you not have a good phone number, or is it just that you have left messages and she hasn't called back?
I don't have a contact. The last time I talked to her was when she had the plea deal in what is it?
All right, well, I'll tell you what,
Last year.
because today's Zoom has been especially delicate, I'm going to reset this to January 20. But I will need for you to contact her and make sure she understands, if at all possible, that she must appear in court. Or I feel a lot of pressure basically to issue a bond forfeiture. So
Understood.
I would rather have her come in willingly.
Yes.
Okay. All right. So January 20 it is. And do you have anything else, Mr. Pettis, with us?
No, I don't.
All right. All right. Then your excuse, sir. Have a great afternoon. Thank you.
Thank you. You too.
And
Can you fix it where I can do a reset? She didn't appear.
yes, let's reset it to January 20. I'm just not sure exactly what her status is. So I want to be sure that she's had notice and ignored it before I issue a warrant. Okay, so if you have nothing further, Mr. Pettis, thank you. You have a great afternoon. Take care. Yes, sir. You're here for. Okay, if you'll, I know, but yeah, but what kind of order is it? Oh, okay. I can do that. Thank you. And you are Adam LaHood? I don't recognize you very well with mask on. But no, don't take it off. Okay, today is the November 1st, right?
Yes, ma'am. Right in November somehow. Kind of scary.
Yeah, it's going fast. Okay. Thank you.
Yeah, thank you.
Thank you.
Have a good day.
You too. Yeah, but I need to take a 10-minute break. Okay. So how are you doing, Mr. Nettles?
I'm doing good. How are you doing, Judge?
I'm doing good.
You have a good weekend?
Actually, I didn't work at all this weekend, and I was really trying to catch up on some rest. But I am very tired, and so I'm going to take a 10-minute break, get some coffee, so I can be really ready to hear this, okay?